Thank you so much, Carol, for that kind introduction, and thank you also to CPAO for the sponsorship. For those of you who didn't know, as Attorney General, professional accountants, as Carol just said, are one of 4 professions I oversee in Ontario, and I've had the privilege to see the creativity and resilience that Carol's leadership has brought, not just during COVID, but as long as I've been able to work with her as AG. So thank you again, Carol. Many thanks as well to today's other sponsors, the Canadian Bankers Association and Waste Connections of Canada. And thanks also to all of you for joining. The times we're in have meant more of this type of interaction, and I know how busy we are, and we're all still working to get this province through to the other side. So I thank you for your time and hope you'll leave today's discussion with some insight into how we've pivoted, not only to keep the justice system running, but to also position Ontario's justice experience closer to public's expectations. Speaking to you today on this issue brings to mind some of the reasons why I made the decision to become a lawyer in the first place. I just finished a master's degree in judicial administration, studying systems and courthouse architecture and rules and why things are the way they are in the justice system. And at that time, I'd been working as a clerk in the courts, and it was my experience in that role that I first recognized the system needed profound change in order to better meet the needs and expectations of people who are relying on it. I also realized that as a clerk, I didn't have the levers I wanted to drive that change. And it soon dawned on me that becoming a lawyer could unlock opportunities to do so. So I went to law school, and I fell in love with the private practice of law and the chance to help people in new ways. But the more experience I gained helping people navigate this awkward and sometimes very broken system, one person at a time, the more interested I became in effecting structural change that could break down barriers across the system. I ran for provincial politics for one reason: to make change, so that I can fix things for thousands at once rather than one at a time. And here I am, Attorney General of Ontario, helping to lead the most significant period of transformation that this province's justice system has seen in my lifetime. It's important to acknowledge that the challenges we have faced in responding to COVID-19 are by no means behind us. In fact, some of the biggest hurdles remain ahead of us as we plan for a strong and sustainable recovery and get to the other side of a crisis that has been felt by every sector and every person in this province. I want to recognize the tremendous work of our frontline heroes in our hospitals, long-term care homes, grocery stores, schools, police stations, courthouses, and law offices. Throughout the pandemic, we've been focused on keeping Ontarians safe, and of particular focus for me, maintaining the administration of justice, and that continues to be a top priority. I'm sure many of you have heard how COVID's disruptive force has forced new approaches to urgent problems in various sectors. But what has been remarkable for the justice sector is how many lawyers, clerks, judges, and other participants were able to finally, and against all odds, cast aside historic distractions and stumbling blocks to finally start getting the job done in dramatically new and effective ways. Each essential to the system in their own important ways, this vast roster of quote-unquote partners were at long last collaborating in ways that suited today's challenges. We went from asking why? Why now? Why so fast? Why not wait and see? To instead asking, why couldn't we make this work? Why wouldn't we take a leadership role? Why shouldn't we take a leap and move Ontario ahead by decades? Why shouldn't Ontarians be able to expect reliability, accessibility, and an experience that aligns with the rest of the modern world? This type of dialogue is very much reflective of the work I and my ministry have undertaken these past 8 months to drive the most significant modernization effort the justice system has seen in most people's memory. Indeed, the recent breakthroughs we've made to move legal services online during COVID-19 have reset Ontarians' expectations for how justice can be done, and at the same time, reset our own perspectives on how to get things done. No one sector or community could or would claim to have a monopoly on the challenges that have emerged as a result of COVID-19. The justice sector, though, has been affected in unique ways due to the complex and often unspoken interconnectivity of justice partners, including practitioners, the judiciary, court staff, support services, and individual users who come together in each corner of our system thousands of times each day across our province. Keeping the system moving involves work done on the front lines and full sight of Ontarians who depend on accessing justice, as well as behind the scenes as thousands of people keep the wheels of justice turning. We hear the term essential service a lot these days, but I would suggest that justice is more than that. It is a value, it is a right that are the foundation on which our province is built. The pandemic has taught us many lessons, but perhaps what should be the starkest for all of us is that the justice system can't close in the face of these unimaginable odds. We have to lean into it. We have to find ways to not only make it work, but to make it work better. From the very beginning of the public health crisis, my ministry and the courts found ways to keep going, Realizing the risks of having large numbers of people congregate in courtrooms and judicial settings, we immediately set to work to move to remote hearings and help the courts with their suspension of in-person proceedings. The Ontario Court of Justice, which hears more than 90% of criminal matters in the province, immediately prioritized urgent matters, including child protection and serious criminal cases, which required in-person hearings, and moved the rest to remote. While this is not an overnight transition, I think we even surprised ourselves by working together how quickly we were able to turn the entire system on its head. And it wasn't long before capacity was expanded to remotely conduct 100% of proceedings involving an accused person in custody. The headlines talked about the use of Zoom to hold hearings in totally new ways and the ability to participate from home. Behind the scenes, we were all hands on deck making urgent and targeted investments to update technology in a sector where fax machines were still an acceptable way of doing business. We had to make sure that staff who had made the sudden shift to working from home had the right equipment to make an even faster switch to a virtual court environment. And I want to pause for a moment to thank all those individuals and groups that pivoted with us. Thank you. This meant hardware, new software training, new software itself, with an urgency that couldn't wait for the normal government timelines or the answer to the ever-important question, why? Why so fast? Why not the way we normally do things? The answer, of course, in these times was obvious. Emergency meetings and late-night phone calls with senior members of the bench and government soon evolved into collaborative working groups where we could pool our ideas and solutions to start to move forward on substantive change. Quick thinking and action brought us solutions like remote attendance at court, digital signatures where only hard copies were allowed before, electronic issuance and sharing of court documents, service by email without the need for consent or court order. In fact, just last week, we worked with the Civil Rules Committee to formalize many of these changes and make them permanent. Proof that we were right to move as quickly as we did. These changes actually made our system stronger by making it more accessible to Ontarians and more resilient to whichever challenges the future might bring. For any one of you who hasn't been involved in the justice system these past decades and is asking an obvious question, the answer is yes. We really did rely on fax machines, millions of pages of paper, and technology that was only just slightly better than Morse code to share information. You may think I'm kidding, but until 2 days ago, Civil Rule 51.01 sub C referenced telegrams. It now says email. To give you an idea of the gap we closed, we went from an almost entirely paper-based system to being able to file almost 450 different documents online within months. We were suddenly in a world where 95% of civil proceedings were filed online and over 70% for family matters. We also accelerated solutions we were already working on so they could be of benefit faster. A huge milestone was fast-tracking a piece of legislation that had been originally part of the Smarter and Stronger Justice Act introduced last December to allow virtual commissioning and notarizing of documents. We saw an opportunity for delivering something faster, and we took it, accelerating access to justice because it made sense and it was the right decision. We also pivoted to accelerate a project to make information about court cases available online. Suddenly, reporters and other court users were amazed to learn that they could now log onto a website rather than lining up at a courthouse to use an ancient terminal one at a time. I expect we'll look back on these terminals and curiously as nostalgic as we do payphones today. Another game changer was our acquisition of the cutting-edge Thomson Reuters Caselines digital platform, a world leader in the industry and now powering online and in-person hearings here at home in Ontario. Finally, we were starting to see pathways that took us beyond crisis response and to longer-term modern solutions that would accelerate justice delivery across Ontario. Of course, we couldn't limit our changes to just new technology. The need for change went beyond remote hearings and file sharing and even beyond our courts. We had to transform the way we do things, not just what we do. It is worth noting, something you all probably already know, the legal system is so much more than lawsuits and courtrooms. I'm so grateful for the wide-ranging efforts of numerous practitioners and practice associations who we consulted with to respond to the needs of Ontarians dealing with estates law and property law and commercial law, construction law, and so many other areas. Their willingness to work quickly and closely with us facilitated advancements that will be an important legacy in these challenging times. A great example of results driven by this very agile responsiveness from our partners is the rapid modernization we undertook in the estates world. Orders were made to allow wills to be witnessed virtually, so Ontarians wouldn't need to meet with lawyers and paralegals in their driveways and on the hood of cars to formalize their affairs. We expanded the number of probate court documents that could be e-filed and began to ask why. There it is again. Why can't we make the entire wills and estates process easier? and a vast consultation began. These quick solutions are continuing to propel us forward in modernizing an archaic system, and I look forward to sharing more in the coming weeks and months on the work that is well underway. As I mentioned earlier, I've been in this system in many ways for a long time, and I've seen it through a number of different lenses: the court clerk position, the court registrar, as an academic, as a law student, as a practitioner, and now as a politician. And I can tell you, I've never seen anything like it. So when I say we move the justice system forward by decades and months, I can assure you, and I think many lawyers listening today will agree, it is not an exaggeration. We could see the culture was changing, and we were building muscle memory around finding the most direct and surest path to fixing problems. Resistance to change was finally giving way to the recognition that we could not return to how it used to be. Then something happened. It succinctly demonstrated that Ontarians weren't just starting to notice these changes. They were participating like never before, and their expectations were changing. Last June, more than 20,000 people logged on to watch a live stream where a Superior Court judge delivered a sentence in a high-profile case. We'll never see a courtroom that big in Ontario unless we start using stadiums built for hockey or baseball or basketball. In September, the Superior Court reported that 50,000 hearings had been conducted virtually in a province where this was all brand new. Both inside the system and outside of it, we knew we weren't turning back. Perhaps the biggest lesson we learned, and I'm sure this is not unique to the justice sector, is that we need to move beyond trying to solve yesterday's solutions and instead use this as an opportunity to address tomorrow's sustainability and resiliency. We also learned that we can't be afraid of changing the paradigm, even if that means rethinking what used to be viewed as golden rules or generally accepted wisdom on how to make things better. For us, that meant we had to decide. Do we keep putting taxpayer resources behind the same plans and presumptions that have led us to this breaking point? Do we throw money at the problem and pretend we're doing something, which is the lazy and irresponsible answer some governments give when they don't know what else to do? Or do we take an approach that is based on innovation, agility, and in some cases, disruption? That last one it's become something of a term of pride and excitement in the private sector, but it still raises more than a few eyebrows in the justice world. One of my favorite examples of how disruption can revolutionize society is how the proliferation of mobile phones allowed some regions of the world to skip the stage of overcoming a landline in the phone infrastructure deficit. A 2005 New York Times headline read, "Cell phones catapult rural Africa to 21st century." The way I see it, we've reached a turning point with an opportunity to make a quantum leap forward, accelerating justice, accelerating modernization, and therefore justice delivery across Ontario in a way that not only transforms how people access justice, but makes it a system people can come to trust and rely on again. So we won't wait, and in fact, we stopped waiting to take action when we saw not only the opportunity, but the absolute imperative to forge ahead. In May, we announced the decision not to proceed with the Halton Region Consolidated Courthouse construction project, a large, expensive project that had been developed years ago as an answer to an outdated question. And it would have been irresponsible to move ahead with it knowing what we knew then and what we know even better now. It was time to literally put our money where our mouth is and start radically rethinking how we invest taxpayer money to benefit everyone more in the near and long term instead of staying mired in an outdated paradigm. We needed a new vision for the outdated courthouses in Milton and Burlington that Halton would have replaced. We will preserve these critical points of access with a commitment to renovate, redesign, and transform these spaces into modern justice hubs that will have a broader reach and technology reflective of the world we live in. Instead of accepting old decisions and ways of thinking, we took an approach that embraced the power of disruption, that has driven advances in so many other sectors that Ontarians interact with every day. And we did it and are doing it by working with the community, justice partners, and the legal profession. We have a chance to make Ontario home to the courthouse of the future, and this is just the beginning. These initial steps are putting us on a path to totally new ways of how we approach capital and other investment planning for the justice sector. My ministry is the second largest property manager in government, so we have our work cut out for us to reimagine what that can look like and what we can achieve. My ministry is also one of the largest employers in the provincial government, so we know we have a leadership responsibility in terms of how we deliver justice services and experiences. By deploying modern technology to broaden the reach of existing courthouses and services and focusing investment on smarter new builds in our communities, we will enhance current access points, create new virtual ones, and overall create a stronger and more resilient network of justice services for Ontarians. Enhancing our reach through technology will bring justice closer to individuals that need to engage with the system and will redefine what access to justice means. There is an opportunity here to revitalize the role of the justice system in our community, to move past the long-held perception of delayed, unresponsive, creaking wheel of frustration to a dynamic, accessible, and transparent system that people can actually rely on to see their critical issues addressed in a timely way that actually makes sense. This strategy is complemented by other initiatives our government is executing, including the government-wide digital first modernization being driven by Minister Bethlen Falvey and Ontario's broadband strategy being led by Minister Scott that will provide key infrastructure and internet access to more Ontarians that need it. It is honestly tremendously exciting to think about how we can break down those barriers to justice that have been part of the landscape for rural, northern, and Indigenous communities for so long. I'll give an example that few of us here have to think about on a daily basis. Currently, remote communities, they're served by a fly-in court model, where sometimes the victim and the accused are ferried between locations on the same puddle jumper of a plane to attend court. Think about that for a moment. The issues around access to justice, victim trauma, and government expense are sobering. We're duty-bound to take these challenges head-on, and we now have the momentum to do it. As we rethink bricks and mortar construction and rebuild our technological infrastructure, inside the system we must continue updating judicial procedures and court and tribunal processes to lend more horsepower to the transition toward a seamless end-to-end client experience. There's been so much of this type of innovation in other sectors, such as banking, retail, and travel, that have dramatically increased the quality of life for everyone here at home and around the world. This very issue is driving me and my ministry to create a user-focused experience, something that Ontarians expect and demand in almost every other sector, and I still haven't heard a good answer to explain why we can't expect the same thing in the justice sector. Imagine if we approached the design of a courthouse with just some of the customer service elements you see in an airport. Both have high volume of pass-through clients every day, with many spending time waiting for an appointment or completing their business. If someone needs to be in the courthouse, we can do a lot better on what that experience looks like. Consider the approach taken by tech giants like Shopify and Amazon, who consider carefully the number of clicks a client has to make in completing their transaction as a basic, important data metric. Imagine the possibilities if we applied that to making the justice system easier to use and navigate online. Answering these questions is essential to achieving that quantum leap I was talking about, moving forward to answer tomorrow's challenges today and leapfrogging past the outdated problems of yesterday. One of the undeniable truths facing us is that for us to succeed, we need more ideas, more innovation, and more perspectives to continue breaking down barriers to a better justice experience for Ontarians. Crowdsourcing better solutions and using competition to drive innovation is by no means a new concept, but it is long overdue for Ontario's justice sector to tap into it. That is why we need to be championing the creation of things like innovation hubs that can engage directly with innovators, entrepreneurs, and tech-savvy players to contribute directly to our transformation. Reaching out beyond the justice sector for non-traditional ideas to shape Ontario's justice experience is, in my view, critical to us succeeding. Imagine seeing private sector players or academic institutions compete in a type of Justice X Prize to accelerate justice in Ontario, a platform that could launch new ways of answering the challenges facing us. We may not build a rocket ship to Mars, but an app that lets you schedule your court appearance from your phone would be a good start from where I'm standing. Let me go back to the 20,000 accounts that logged in to live stream that sentencing in June. Why shouldn't we be able to access all public hearings with a single click? Why couldn't we make this available on YouTube channels? A simple thing for most of you listening, but for many it's viewed as too much, too fast, it's far too disruptive. Are we ready for it? It's a discussion worth having, and I'm excited to engage in. It's these types of discussions that need to be taking place across the sector to drive the changes we desperately need. The pandemic showed us, in stark terms, how far behind Ontario's justice system had fallen. New thinking and quick action put us on a path that can actually achieve what Ontarians have been crying out for decades. We became numb to hearing that justice delayed was justice denied, paralyzed by the scale of what needed to be done. Now, we know better, and we'll do better. Truth is, the naysayers won't recognize the system they think they're protecting. It has changed forever. In this new approach, justice accelerated means justice delivered. We are just getting started, and I can't wait to see where we get to. Thank you. Merci. Miigwech.